haven't been told what ADAI stands for, so apologies.
It is Institut de Droit des Affaires Internationales, so an Institute for International Business Law.
I think we've lost our chair, but I assume you will join back soon.
Apologies for that, everyone. I got a notification on my screen, clicked out of it, and then I got kicked out of the room. So I think I can remember just about where I was. So this is, so we have the appellants are, just checking people's backgrounds because I know, so the appellants are in my top right, I believe. That's Marmara, is that correct?
It is correct.
Afternoon. I don't have your names on the Zoom, so could I have your names, please?
You can actually find our names in the chat box. We already write it down there.
Thank you very much. Great. And then we have the respondents are Cairo, who we have in two separate screens. Is that correct?
Yes. Yes, Mr. Arbitrator.
I can see both your names on the Zoom there. In terms of the arbitration, you've got myself, Mr. Kevin Carpenter from based in the UK. Then we have Philippe on my top left. Philippe, if you'd just like to give a brief introduction to yourself.
Yes, good afternoon, everyone. My name is Philippe Bärtsch.
And then we have Gorsha in my bottom right, who is I believe, in the United States.
Hello, everyone. My name is Gorsha, sir. Yes, I am. I'm in California, in fact, as you can see by my beautiful background. It's not a real picture, but I'm not far away. Good luck, everyone.
Thank you, Gorsha. Mine is also not an actual background, as you may have gathered. So moving on to the moot itself, I believe you've all had a discussion about the procedure. I see in the chat box that I've got the names there of the people from Marmara. Oh, sorry, no, from Cairo? Oh, from Cairo in the chat box. Have you agreed what order you're going in, how much time, etc.?
Actually, Mr. Arbitrator, parties didn't agree on a specific structure.
Right.
Since the appellant side actually requests to follow the common procedure, which actually follows as the respondent counsel for procedural issues shall go first, followed by the appellant counsel for the procedural issues. And regarding the merits of the dispute, the appellant's counsel for the merits will go first, and the last pleader will be the respondent counsel for the merits. The appellant actually requests this common structure, and about the time allocation, each pleader will have 9 minutes for completing their arguments and 1 additional minute for rebuttal and surrebuttal.
That is okay with me. Is that okay with you, Cairo?
Mr. Arbitrator, we do agree for the time limit, but not really for the respondent starting on the procedural issues, because we don't feel it's very logical to answer the challenges for arbitrators and the admissibility of evidence before hearing what the appellant has to say about it, as we are the respondents, not the appellants. So we leave the choice to you. Thank you.
I would have expected it to be appellants followed by respondents on the procedural and then on the merits. Is there any particular reason, Marmara, why you propose something different?
No, Ms. Arbitrator, we just actually request the common procedure in international arbitration, but nothing further than that.
Okay. Are you okay going first on both parts?
For the merits, yes, and for the procedure, yeah.
The procedure, okay. So we will go appellant, respondent, appellant, respondent, and then rebuttal time at the end. Or do you want some rebuttal time after each part?
Yes, actually.
So some rebuttal time for procedure and some rebuttal time for the merits. Is that what you would like?
Yes.
Right. Okay. well, we will have to build that time in. I say we're already up to sort of 20 past 2 at the moment. Sorry, UK time. So we may look more to sort of 8 minutes per submission, Marc, on that point. But I would welcome, if we're going to do it in that way, for the appellant counsel in respect of the procedure to open the proceedings, please. Thank you.
Honourable members of the tribunal, good afternoon. My name is Arda, Tekin, and I'm here to represent appellant for the procedural issues of the case. And my co-counsel, Asena, Fulya, Seyrekbasan, will be explaining the merits of the case. Procedural issues in this concrete case are divided into 3 parts. Firstly, the challenges against Mr. Bärtsch should be upheld. Doctrinally, chess arbitrators should be particularly sensitive about conflict of interests, and especially with their relations with the parties. There are some details regarding the comment of Mr. Bärtsch which should be discussed in the context of independence and impartiality of an arbitrator. May I draw your attention to the page 4, paragraph 11. Has the tribunal with me? It can be seen from the paragraph that panel was constituted on the 29th of 2021. On paragraph 12 of the same page, it can also be seen that comment of Mr. Bärtsch published 9 days before constitution on November 20, 2021. Considering the short amount of time gap between the events, appellant's position on the anti-vaccination both domestically and internationally, this is an undeniable fact that approach of Mr. Bärtsch is still current and shall be considered as threat to independence and impartiality. Additionally, the fact that this comment remains on the only comment made by Mr. Bärtsch on LinkedIn to date and examine the language towards the supporters of anti-vaccination movements, such as classifying these people as egoistic, uneducated, and are certain proofs of Mr. Bärtsch's high sensitivity about the matter and rightly makes the appellant worried about the outcome. From a different perspective, the Sanyang case is one to be mentioned. In this case, the panel agreed that an arbitrator is free to defend his convictions on social media. However, an arbitrator must still express any opinions with a certain restraint and irrespective of whether he is acting in his capacity as an arbitrator. Thus, the tribunal has annulled the cast vote for bias of its panel chair. Secondly, the evidence, including the telegram conversations, relied upon the support of the FIFA appeal decision is inadmissible. In accordance to Article 46 of FCA, proof has been obtained by means or ways involving violation of human dignity or obviously does not serve to establish relevant facts shall be rejected. Additionally, may I draw your attention to page 8 procedural order, question 23. It is explicitly stated that it is still unclear that if the telegram conversations were extracted from Mr. Adams' phone. Considering the seriousness of bribery claim, severeness of the sanctions, and reputational damage that the appellant will endure, solely because of the non-proven evidence will contradict human dignity, which also includes psychological damage in its definition. And as additional legal background, IBA rules should be taken into account. According to IBA rules, Article 9, Section 3, the arbitral tribunal may, at the request of a party or on its own motion, exclude evidence obtained illegally. In light of the mentioned provision, the commentators affirm that hacked conversations shall not be accepted by the panel, unless one of the parties will issue a waiver in cases where the evidence is illegally obtained and brought by the third person. Even if the telegram conversations truly belong to the appellant, the evidence still remains inadmissible because it is common practice that admitting the evidence without consent of the appellant held in breach of right to privacy. further than it constitutes a contradiction to principles of good faith and fair dealing required in international arbitration. Thirdly, the anonymous witness statement taken by Heartlandian authorities should not be accepted due to violation of right to be heard. Case Code 41.2 states that matter exemption of the witness appearing in the hearing, it could be possible with the agreement of the parties if the witness or expert has previously filed a statement. The appellant does not accept this matter due to lack of cross-examination on whistleblower on such a serious allegation. With the knowledge of importance of this evidence for awarded sanctions by FIFA, it must be held into account that the European Convention of Human Rights underlined that a conviction cannot be based either solely or to a decisive extent on anonymous statements. The parties should not be prevented from testing the witness's reliability, and evidence derived from treated with extreme care. This whistleblower fears that the football fans may want to retaliate against him. However, this does not prevent any party either on Heartlandian criminal proceedings, FIFA's investigation, or CAS proceedings to cross-examine him while protecting his or her anonymity. In Carpenter case, CAS held that use of protected witnesses is subject to CAS following strict conditions: that the witness motivate their request to remain anonymous in a convincing manner, and that witness statements are questioned by court itself, which must check their identities and reliability of their statements, that witnesses are cross-examined through an audiovisual production system. Even with the acceptance of concrete retaliation risk, which whistleblower claimed against the football fans, but not Mr. Atom, the protected witness statement without questioning by the decisive authorities in person and cross-examined by appellant through an audiovisual protection system would surely not meet the mentioned conditions above and considered a violation of right to be heard and a fair trial, as it is stated by CAS with a closely similar about. And it must be also noted that on another CAS arbitration in which FIFA was respondent, FIFA stated that witness statement of the opposing party would have to be excluded from the file, as FIFA did not have the opportunity to cross-examine their witnesses. Contradictory approaches on such matters by FIFA only because witness statements on its benefit this time is absolute proof of its ill intentions. Therefore, I have to conclude my case with the procedure. Thank you.
Thank you very much. Just in terms of, you mentioned you'd put the names in the chat box. They haven't appeared there at the moment, so I've only got the ones of Cairo. So if you could just retype those, Marmara, please, when you've got a moment, that would be helpful. In terms of the submissions themselves, Philippe or Gorsha, do you have any questions for the first orator there? I think my couple of questions from me, if that's okay, just brief ones. You mentioned the IBIA rules. Do we have a copy of those, or would you be or?
Currently, I do not have the copy of the IBA rules.
No, that's fine. And also, which of the you mentioned a case towards the end where FIFA had apparently asked for a statement to be struck out. Could you tell me the name of that case, please, just so I can check with the authorities?
Mr. Arbitrator, due to our internet connection, I lost you for a second. Would you ask your question again, please?
So yes, you mentioned a case towards the end of your submissions.
Yes.
Which was where FIFA themselves had asked to have a witness statement struck out.
Yes.
Which case is that, please?
We can actually put the case number in the chat box.
Yes.
If you actually wanted to see.
Yeah, so if you could do that, please, and if you could put both names in the chat box as well, please.
Okay.
Yes, thank you. That's everything. Thanks. Ms. Makke, apologies for the pronunciation.
Yes.
Please go
Can I
ahead.
start?
Yes, please.
Okay, thank you. Mr. President, honorable members of the panel, by means of introduction, my name is Rola Makke, and I'm the counsel of the respondent, FIFA, alongside my co-counsel, Marc Bondoky. I'll be handling the issues showing that challenges against Mr. Vax and Ms. Sarah Umayma should not be upheld, and that the evidence relied upon in support of the FIFA appeal decision is admissible. And this in around 10 minutes, then my co-counsel will address the last two issues on case merits, showing that the appellant breached Article 27.1 of the FIFA Code, and that sanctions imposed by the virtue of FIFA appeal decision was proportional in the remaining time. Starting with the first issue, regarding the challenge of Mr. Vax. 3 days before the hearing, Mr. Vax's comment criticizing people who refused to be vaccinated was discovered by a member of the appellant's legal team who invited him to resign, and further informed the panel that he would formalize the challenge at the hearing if Mr. Vax failed to resign by then. We do not find the timing argument of the appellant a relevant factor for their argument. To start with, procedurally, Article R34 of the Task Procedural Rules precises that the challenge of an arbitrator shall be lodged in the form of a petition, setting forth the facts giving rise to the challenge, which shall be sent to the CAS court office. This hasn't been done by the appellant. So formalizing the challenge once in the hearing is not admissible. And to assure this, the panel cannot decide on its own independence and impartiality. Second, the opposite invoked the Sun Yang versus Wada and Fina case to apply on conflict of interest. It is true that in this case, the arbitrator was dismissed, but we are sure that they are comparing uncomparable acts, as the arbitrator in the said case used violent and highly discriminative expressions and offensive tweets, and they reveal an unconscious bias, as was proved by the plaintiff. And in our case, the comments of Mr. Atta were not intended to Mr. Atta, and they were just a simple opinion and a widely discussed matter. And we should ask ourselves whether Mr. Vax's comment on LinkedIn is enough to challenge him. In our view, they are creating a non-existent problem to trouble the process of the arbitration. It is just an opinion on a worldwide issue that is not related by any means with the arbitration in question. It is an external opinion. So we remind the opposite counsel that Mr. Atem is here because he violated the law and not because of his views on the pandemic's vaccine. We find it surprising that the opposite counsel didn't give his arguments about challenging Mrs. Umayma, even though it was one of the issues raised. We will give our opinion very briefly on the matter. Regarding the new associate, we say that he joined Mrs. Umayma's firm around only 1 week ago, and he was not involved in any disciplinary proceedings against Mr. Atem. And regarding the repeat appointment, we say that sports arbitration is a field where it is of custom and practice that parties frequently appoint the same arbitrator in different cases. Now to the next, after saying that Ms. Umayma and Mr. Vax should not be challenged, we go to the next issue. We assure that the evidence relied upon in support of the FIFA appeal decision is admissible. To prove our idea, we will follow the same rationale followed by CAS panel in the case Manchester City Football Club Limited versus UEFA in 2020. Article 184 of Switzerland's Private International Act, the PILA, provides as follows: the arbitral tribunal shall take evidence. The current arbitration is seated in Switzerland. So, to prove applicability, we cite a case of CAS, it's IAAF versus Araf and Anastasia Bazdireva. It's a case of 2016 that provides arbitral tribunals in international arbitration proceedings that are seated in Switzerland with ample latitude in the taking of evidence. In general, the power of the arbitral tribunal related to the taking of evidence is only limited by procedural public policy, the procedural rights of the parties, and where necessary, relevant sporting regulation. No infringement of procedural public policy or relevant sporting regulations was addressed by the opposite counsel, and we will later go back to the procedural rights of the parties. Applying Article 152 of the Swiss Code of Civil Procedure that requires, in case of illegally obtained evidence, a balancing of interests, we assume that there's an overriding interest in finding out the truth that prevails on Mr. Atham's personality rights. So it is important that FIFA is not alleged to have been involved in obtaining the telegram messages, nor asked for the statement given by the whistleblower. In the same case, the panel found that the interest in discouraging people from engaging in such illegal hacking by excluding the evidence is outweighed by the public interest in holding this person accountable for its alleged wrongdoing. And this can easily be applied to Mr. Atham because, as we all know, the fight against corruption and bribery is not only of private interest, but indeed also of public interest. Gianni Infantino, the FIFA president himself, said that there's an absolute commitment of FIFA and of himself as FIFA president to assume a zero tolerance policy on corruption and football. This in a meeting with United Nations Office on Drugs and Crime in 2020. Now, getting back to the procedural rights of the parties, we assure that there is an absence of need for cross-examination. The opposite counsel based his arguments on the right to be heard and on good faith. We find that there is no need for such cross-examination given that the whistleblower had already been examined by a judge in the context of the Heartland criminal proceedings, and we assure that reprisals against the witness are feared. The appellant wants to cross-examine personally the witness, but we assure that Article 44 of FIFA Code of Ethics about anonymous participants
I believe we have a connection issue. We'll just give it. We'll just give her an extra moment to come back.
I am back. Can I know, please, where I got cut?
Yes, I believe you were Article 40. I think it's 44, was it?
Yes. Okay.
Yes,
perfect.
Article 44.
I'm sorry for this.
No problem. Please go ahead.
Okay. So this article permits exceptions when a person's testimony leads to threats to his person or put him or any person close to him in physical danger. And this is what we fear. Article 71 of the same code on the right to be heard says that the right to be heard can be restricted in exceptional circumstances, like when the witness needs to be protected. Additionally, there is a wave of restrictions being set on limiting cross-examination. We say that the Swiss Federal Supreme Court, in a decision of 2014, in its paragraph 2.1, assured that a party who wishes to rely on the right to be heard with regard to limitations imposed to cross-examination would have to specify which question it was prevented from asking and how they are relevant for the decision. And this has not been done by the appellant, obliging us not to go any further in this question. Consequently, the panel is to find that Ms. Umayma and Mr. Vex cannot be challenged, and the messages and the statement comprise admissible evidence. May it please the panel, I shall now give the floor to my co-counsel, Marc. Thank you.
Sorry, just 1 minute, Mr. Bondoky. Yes, Philippe, please.
Yes, thank you, Counsel. I had a question. You referred to a decision of the Swiss Supreme Court of 2014. Can you give me the reference and just tell me what this case was about in a nutshell?
Yes, it is 4A_544/2014. In this case, there was some experts who were not, where the parties could not ask the question, who were not cross-examined by the parties. And in this case, the Swiss Federal Supreme Court said that it wants to limit the wave of people trying to cross-examine any person. So they put some limitations and pushed the people to say what questions they were prevented from asking to the expert and how this question was relevant to let them cross-examine. This is the fact. We can say that we can apply this to our case because we can compare a witness to an expert and not let the appellant just say in general that we want to cross-examine without knowing what were their questions. Thank you.
Thank you, counsel.
I have a question.
Yes.
To Ms. Makke. Ms. Makke, you were arguing that FIFA has a zero tolerance policy toward corruption. Now, in your view, does that outweigh the individual right to be heard in proceedings, and how would that play out in the context of sports arbitration?
Yes, of course, FIFA has this zero tolerance policy, but never it will let a person be a victim or have sanctions if he does not deserve these sanctions. And to balance this with the right to be heard, we used the Article 44 of FIFA Code of Ethics to show that this right to be heard can be limited if there are some circumstances like the protection of the witness that limit these being able to do so. So this is my answer, Mr. Arbitrator.
Thank you.
Thank you very much. Thank you to both parties for your submissions on the procedural issues. Marmara, sorry, just to repeat, we don't have your names on the. They're still not in the chat area. No, not on my screen anyway.
We actually can see our names, but we're gonna redo it.
Yes, if you could please. Yeah, they're not showing up on my chat. Perhaps because we came back in from a breakout room potentially. But thank you if you could do that. Thanks. So, Mr. Tekin, you spoke first. Yes. Miss Seyrekbasan. Is that okay? I just had to read that. I had to read that very quickly and try and compute it. So I hope that's okay. Apologies. Thank you both. So are you ready, Marmara, for your submissions on the merits, please?
But before that, I think the person has to rebuttal.
Yes, sorry, apologies. Yes, please go ahead.
May I start?
Yes, please.
I have to point out that it is a concrete proof and a huge contradiction that in a previous case, FIFA raised objection because they did not cross-examine the witness. But for this proceeding, the same FIFA did not give the same opportunity to the appellant. Thank you.
That's very clearly put. Thank you, Mr. Tekin. So, moving on from the procedural issues onto the merits, please. Thank you.
But if I'm not mistaken, I think it's for the respondent side to rebuttal for a procedure.
I don't believe there will be any. I don't think there's any need for any rebuttal after that comment. To be honest, I think we're just better off moving on, please, if we can.
Okay. Of course.
Thanks.
Honorable members of the tribunal, good afternoon from Turkey. As already introduced by my co-counsel, my name is Asena Fulya Seyrekbasan, and I will be represent the appellant side of the case on the merits of the dispute at hand. And the structure of the counsel for the appellant's pleading will consist into 3 different arguments. Firstly, the approach of no sliding scale should be applied when evaluated evidence. Secondly, the requirements of Article 27 of FIFA Code of Ethics did not occur in the present case. And lastly, the imposed sanctions shall be considered disproportionate by the panel. started with the counsel for the appellant's first argument. Opposing counsel will possibly argue that the comfortable satisfaction should be applied in a present case. And we wanted to highlight that the counsel for the appellant completely agree with the fact that in the vast majority of the ethics cases, the panel truly applies the comfortable satisfaction. However, there is a vital detail which should not be overlooked in terms of an exception, because in case of serious allegations like bribery and corruption, as in our case, there shall be higher degree of confidence in the quality of evidence, since the bribery allegations considered as the most serious allegations in the sports industry, like the opposing counsel already mentioned. So, and the appellant side of the case was not the only party that examines the no sliding scale in this regard as well, because even in a previous case award, the panel explained, and I quote, "The standard of proof in all cases shall be determined on a sliding scale from, at minimum, a mere balance of probability for the least serious allegations, up to proof beyond a reasonable doubt for the most serious allegations." End of the quote. Thus, it is indisputable that for the most serious allegations, which can be described as bribery and corruption in the sports industry, the evaluation of the evidences should be examined without a sliding scale. Moving on to the appellant's counsel next argument, Article 27 of the FIFA Code of Ethics should be taken into account. But when we look at the wording of the provision, when we examine the wording of this provision, it is undoubtedly explicit that what is prohibited under the Article 27 is undue advantages. And turning back to our case, may I draw the arbitral tribunal's attention to page 8, Exhibit 3. Is the arbitral tribunal with me?
Please.
Thank you. So we can all see from the page that there is a concrete proof that the appellant actually reimbursed the trip to Mr. Kaiser regarding the reimbursement, as can be seen from this received concept part. And furthermore, in any case, the sanction of imposition of a ban on all football-related activities for 15 years is disproportionate and excessively severe. The impure sanction, firstly, does not strike the necessary balance between the deterrent and retributive effect such a decision ought to have and the necessary restorative element. Firstly, returning back to our informations about the case, we all know that the appellant has been in this football industry for approximately 15 years. And in case law, if I actually give you an example from a previous case award, even the 6 years of ban is considered a stain on the appellant's career and impose preclusion from serving the support to which he has dedicated his life. End of the quote. So it is indisputable that the 15 years of ban has to be considered as the most significant stain on the appellant's career in our case. And contrary to what the opposing counsel mentioned, it should also be highlighted that, like the bribery and corruption charges, the gifts, conflict of interest element, and breach of loyalty charges against the appellant are without legal or evidentiary support. The bribery claim has devastated the appellant's career, both economically and reputational. He has, firstly, the appellant has become the biggest corrupter in the eyes of the public, and it is just impossible for the appellant to work even after the 15 years of ban in public quoted companies. And additionally, there is another detail which can be found in the mob case that Mr. Adam had never had allegations against him like bribery and corruption during all of his 15 years professional lives. So, considering the fact that the appellant has a reputable 15 years in the football industry, And given a 15-year ban to an individual which has been in this industry for 15 years is technically and practically equals to a life ban, and forced the appellant to retire and lost all of his economic independence as well. And actually, when we look at from a different perspective, it is obvious that such a ban is not necessary to reach the envisaged goal when there are already alternatives listed in Article 7 of FIFA Code of Ethics. So if the panel actually insists about the bribery claims, that kind of approach will be actually not enough for the panel to actually give the appellant a 15-year case as well in both two different possibilities. So the appellant has a sanction which should be limited to a warning or a reprimand pursuant to Article 7, paragraph 1, let A and B of the FIFA Code of Ethics. Moreover, but regarding the 50,000 francs, actually, even though the appellant already reimbursed 20,000 francs, which can be seen from the receipt, the most important question in here is still remained unanswered by the opposing party. What is the calculation method when it comes to 50,000 francs when the appellant had already reimbursed 20,000 francs for the whole trip? So in conclusion, Mr. Adam, it is obvious that the appellant will suffer the most discredibility, which will continue for the rest of the appellant's side, even though the claims, which actually the opposing counsel also mentioned, are not did not have 100% certainty and are explicitly lack of legal grounds. In conclusion, we kindly ask from the arbitral tribunal to reduce the imposed sanctions on the appellant and did not apply Article 27 of the FIFA Code of Ethics on the appellant's side. Thank you.
Thank you very much. Philippe, I believe, did you just raise your hand?
Yes, thank you, counsel. I have a question. If I understand your position correctly, I mean, one of the arguments that you're making is that the appellant returned the alleged improper advantage and therefore did not violate Article 27(1). My question is the following. Do you have any case law legal authorities supporting the view that the fact that the alleged improper advantage has been refunded or returned would somehow remedy the original action?
Actually, I think the most important legal authority for your question is still Article 27 itself, because when we examine the wording of Article 27 of FIFA Code of Ethics, we cannot see any time limits regarding the reimbursement payment made by the appellant to be considered undue or due. So it is an obvious proof, even we can actually found information in the Marc case, that there is only one link between Mr. Kaiser and the appellant, which is the trip. And moving on to the fact that the appellant actually reimbursed 20,000 francs itself is the main source in accordance with the Article 27, that it cannot be considered as an undue advantage. This is your question.
I was not very clear, counsel. What did you argue as would an appropriate sanction in this case, if any?
We actually request from the panel to consider it disproportionate, especially about the 15-year ban for all football-related activities, and additionally 50,000 francs monetary sanction because of the fact that the appellant already reimbursed the whole trip to Mr. Kaiser.
And you mentioned a case in support of that. That was the Makke case, is that correct?
Can you rephrase your question, Mr. Arbitrator? I didn't hear you well.
The legal authority that you relied upon to say it was disproportionate, was that the FIFA and Makke case decision?
There is an actually case award which was between Joseph Blatter versus FIFA on 2016, and the panel in this case actually considered even a 6-year ban as disproportionate. So when we consider the 15-year ban in the current dispute, when the panel actually just considered even a 16-year ban as disproportionate, of course, 15-year ban has to be considered disproportionate as well.
Thank you for clarifying.
Gorsha,
did you have anything else to add?
Well, I don't think my question was answered. What would be an appropriate sanction in this case, if any?
As I already mentioned during my pleading, if panel still insists about the bribery claims, there are many alternatives in Article 7 of FIFA Code of Ethics. So if the panel actually insists about the bribery claims, it should be, the sanctions should be limited into a warning or a reprimand, which can be found in Article 7, paragraph 1, A and B sections.
Thank you. That is more clear. And what about the monetary sanction? Would you, so you argued that 20,000 francs were already reimbursed. So should we reduce this monetary sanction by 28,000 francs, or should we eliminate it completely?
The second possibility will be actually, I think, the right approach for the case at hand, since the appellant already reimbursed the trip. So it is not the appellant's side for make any additional payments to the FIFA as well. So it should be eliminated completely, briefly.
And counsel, do you give any weight to the argument that might be potentially raised by your opponent that reimbursement occurred after the criminal proceedings had begun in a criminal case?
If I understood your question correctly, you actually mentioned that after the criminal proceedings, which was actually taking place in Heartlandian, the reimbursement payment made after the criminal proceedings. So you wanted to elaborate on that issue, if I'm correct?
Yes, please.
Okay. So first of all, of course, there is a huge difference between criminal proceedings and ethics proceedings. And secondly, since the appellant was not the part of Heartlandian criminal proceedings, we cannot actually say that the appellant actually has some ill intentions regarding the payment, because what actually the appellant did was also avoiding from that kind of possibilities, because and actually the reimbursement payment itself proves that the appellant has not did not have any consent or did not have any intentions regarding the bribery claim, because as soon as he actually found out that there were some criminal proceedings, he actually reimbursed for all of the trip. So I think this argument can be a concrete proof just for promoting our arguments.
Thank you, counsel.
Thank you very much. So we'll move on to the respondent now, Mr. Bondoky, please. Thank you. You're on mute.
Sorry. Okay.
Perfect. Thank you.
Can I start? The FIFA has zero tolerance for bribery and corruption. Dear President and honorable panel members, my name is Marc Bondoky, and as mentioned by my co-counsel, I'll be tackling the last two issues. First is proving the appellant breach of Article 27 of the FIFA Code of Ethics, committing bribery, and secondly, the proportionality of the sanctions applied for him. I will address my first issue in 4 arguments and the second issue in 2 arguments. First issue, the first argument, appellant committed bribery and breached Article 27 of the FIFA Code of Ethics. So in fact, Mr. Atem accepted an offer for a luxurious trip as an undue advantages, in addition to the offer made for a friendly game and keeping its revenue as an additional personal advantages for his wife, the only shareholder of broadcast in Tiny Land, which clearly affected his official duties and made him sell his vote to Big Land in the World Cup election 2026. And by analogy, a jurisdiction from the CAS, Mr. Guzman versus FIFA, when he was found guilty of bribery, breaching Article 27, gaining a personal profit, he got banned for 7 years and paying a fine of 1,000 Swiss francs. Accordingly, Mr. Atem accepted several undue advantages from the Football Federation of Big Land for the execution of official acts and thereby breach Article 27 of the FIFA Code of Ethics, committing bribery as per Article 322 of the Swiss Criminal Code, meeting all 4 bribery requirements, which affirm that the test of comfortable satisfaction is met. Second argument, the time plan is the major proof of the appellant's bad intention. So Mr. Kaiser invited the appellant to vote for big land on the last day on the trip in July 2016. However, Mr. Atom decided to transfer 20,000 Swiss francs to Mr. Kaiser as reimbursement for the trip to big land when on September 8, 2018, after 2 years and 2 months, which is also a day after a Hardline judge issued the convictions that they had sold their vote of Football Federation of Hardline to Big Land in exchange for a luxurious all-inclusive trip to Big Land with multiple gifts on September 7th, 2018. So the question here, why didn't he reimburse him back in July 2016 then? So he's totally aware of his infringement. Third, the appellant is being accused based on intentions and actions, not only for the written words. So Mr. Kaiser written words in the letter invitation, as per reference 1, is asking the appellant to come for future business cooperation. However, he made him and secretary several offers that they could not decline. So his bad intentions appeared clearly when he lured the appellant to vote for big land in exchange for several personal advantages, as per the FIFA Code of Ethics and the Swiss Criminal Code. So everything has its cost. You cannot get all the luxurious advantages just as an act of kindness or friendly cooperation. And reference 5 confirmed my argument. So a conversation between the appellant and his secretary, thinking that selling their vote for the World Cup election would be the least thing they can do in exchange for the numerous advantages, either for them or for the appellant wife. Fourth, the smaller countries' votes are easier to get in football. So getting the vote of a small country in football would be a lot easier than big and popular countries, which make it clear why Football Federation of Big Land would target the appellant to get their vote for the World Cup election 2026. So the timing was very decisive of the goal of Mr. Kaiser. For instance, during the vote for the World Cup 2022, Tahiti and Nigerian officials were banned for requesting to finance football pitches in their country in exchange for their vote from the host. So to conclude with the first issue, everyone is equal in front of the FIFA Code of Ethics to preserve the integrity of the sports, as it also affects not only the sports, but the public interest. And now to move to the second issue, the sanctions applied on the appellant are very proportionate. First argument, appellant's infringement exposed him to severe sanctions. So as per Article 27, paragraph 3, the sanctions for bribery should be a minimum of 5 years of banning, and that's subject to increase based on the football position. Secondly, as per the FIFA Code of Ethics, the appellant did not only commit bribery, but he committed 9 violations. So let's elaborate more. So the appellant committed violation of Article 13, general duty, 14, duty of neutrality, 15, duty of loyalty, 19, conflict of interest, 20, offering, accepting gifts and other benefits, 18, the duty to cooperate, Article 21, commission, Article 25, abuse of position, and that's in addition to Article 27 of bribery. And each of these violations we mentioned beside bribery shall be sanctioned with an appropriate fine of at least 10,000 Swiss francs, as well as ban from taking any part of any football-related activity for 2 years. Third, given the fact that he is committing violations on both national and international levels as a high-ranking official, and that's subject to increase the banning based on his official. So by doing the calculation, we will find that the appellant breach committed bribery shall be sanctioned for 5 years, plus 6, at least 5 years, plus 8 sanctions each of 2 years. So that's a total of banning 21 years. And regarding the fine, if you calculated at least 1,000 Swiss francs for bribery and 10,000 Swiss francs for each of the 8 violations, so that should be a total of 180,000 Swiss francs. So looking at the fact that the sanctions of 15 years of banning and 50,000 Swiss francs applied is fully deserved, as the appellant good manners were not respected and even the mitigating factors were respected. So by analogy, a case of Jerome Valka versus FIFA, the appellant was fined 1,000 Swiss francs and banned for 10 years, 6 of them for undue benefit, violating Article 20, and noting that the appeal was dismissed. Second argument in second issue, the appellant received personal advantages, nor gifts or hospitality. So as per the gifts and hospitality FIFA directives, we do business the right way. It's okay to accept and offer small gifts, reasonable meal and hospitality, where there is a legitimate business purpose. But you must never offer or accept gifts or hospitality in exchange for improper advantages. Appellant is aware of the bribery committed as per the FIFA Anti-Corruption Directive. Prior to offering or accepting a gift or hospitality, we must ensure that there is a clear business purpose and that an outside party could not interpret the gift or hospitality as an attempt to improperly influence the decision. So in fact, the luxurious gifts received by the appellant were not reasonable and in exchange for improper advantages, which is the vote to big land in the election of the World Cup 2026. So as a result, Mr. Adam deserved the sanctions applied on him as he violated laws from the FIFA Code of Ethics, FIFA Anti-Corruption Directive, Swiss legal requirements provisions, FIFA Code of Conduct, and the CAS anti-corruption policy. And as the FIFA has zero tolerance for bribery and corruption, thus it imposed deterrent sanctions for anyone who attempt to involve in such cases, maintaining the integrity of sports. And to conclude with the rebuttal, the opponent counsel failed to mention the IBA guidelines and provisions in their legal authorities. Second, we proved how all four requirements were fulfilled to commit bribery, and the sliding scale and mitigating factors has been considered in the sanctions applied. Other point to mention that the sanctions applied how seriousness of the bribery and other violations committed. So we should not tolerate with the corruption and accept excuses for bribery or corruption. On the other hand, did the Article 7 decide that we cannot apply ban or fine and only reprime? That's if you look at the severity of the sanctions applied and the right articles who sanctioned those violations, we will find that he should be banned and sanctioned with a fine, not only fine or not only reprimand. Also, failed to, on the case you mentioned, you failed to clarify the 6 years was disproportionate for which matter of facts. So the facts were very important. Moreover, you failed also to show on which legal basis or the article the opponent counsel referred. So you failed to mention how the sanctions applied should be referred to which legal base. And in a case mentioned in the appellant legal authority is Karimuddin versus FIFA. Here, the appellant only committed 2 violations of Article 23 and 25. However, the panel find that a lifetime ban and 1 million Swiss franc is very proportionate, despite that he only committed 2 violations.
Sorry, Ms. Bondoky, you need to wrap up, please.
And to summarize, it's crystal clear that the FIFA didn't respect the FIFA Code of Ethics, Swiss Code, and the proportionality of sanction. Therefore, the panel must take into consideration that challenges against Mr. Vax and Ms. Sarah Omaima should be upheld. The evidence relied upon in support to the FIFA appeal decision is dismissed, and the appellant breached Article 27, committing bribery, and sanctions applied on him are very proportionate. On behalf of the respondent, we thank you for your sincere attention.
Thank you. I suspect most of any rebuttal has been covered by Mr. Bondoky's submission, so I don't think we'll need to hear anything further from the respondents. In terms of questions, I have a couple of questions, but I'll just ask one in case one of my fellow panel members wants to ask a question. Mr. Bondoky, you mentioned at the start of your submissions, you made brief reference to the Swiss Criminal Code. What relevance does that have to this case, please?
Yes, sir. So I quoted from the Swiss Criminal Code the definition of bribery, as it's clearly defined the definition of bribery. So as per article, let's check. So it's clearly defined the bribery as applied to our case. We will find it exactly committed bribery as per the Swiss Criminal Code. So we only refer to the code in Article 300/2022 in the definition of bribery.
Okay, thank you. Any further questions? No?
I have a question.
Thanks.
Well, since we're on the subject of Swiss criminal code, so does that definition of bribery that you described under Swiss criminal code, is that the same definition of bribery as under the FIFA statutes?
In fact, it supports the definition of bribery in the FIFA Code of Ethics, Article 27. So, for example, the definition of bribery as per Article 322 of the Swiss Criminal Code is any person who offers, promise, or gives an employee in private sector an undue advantages for that person or a third party, for that person carries out or fails to carry out an act in connection with his official activities. And if you compare the definition of bribery in the Swiss Criminal Code for the FIFA Code of Ethics, you will find it that the appellant committed the bribery as he accepted undue advantages, and that affected his official duties and made him look at his personal interest over his federation interest, affecting his official activities and voting to be aligned in the World Cup elections 2026.
Now, Council, if you draw a parallel to between the FIFA Code of Ethics and the Swiss criminal law, should we apply the same standard as standard of proof as would apply to in criminal proceedings in Switzerland?
I'm sorry, sir. Could you just repeat the question again?
Yes, my question was, as you draw a parallel between the FIFA Code of Ethics and the Swiss criminal law, what standard of proof should we apply in this case?
So in this case, all persons who are officials in the FIFA should be binding to the FIFA Code of Ethics. The reason why I referred to the definition of bribery Swiss criminal code is to make the analogy, to confirm that even in the Swiss criminal code definition of bribery, so referring to another reference to support my argument, the appellant committed bribery. So bribery is one in all so bribery is almost similar in both in both references. So the reason why I use it is to support my argument. However, all person who binds for any FIFA officials or football federations shall bind to the FIFA Code of Ethics, and we proved how the appellant breached Article 27, meeting all 4 requirements of bribery.
I think for reasons of time, yeah. I think for reasons of time, we're going to have to just move on, Gorsha. I understand that the question wasn't clearly answered, but we have to keep in the time limits. Okay. Everyone, thanks. Marmara, please, just a very brief, if you can, please, given the time restraints we have, just a brief response, please.
Thank you, Mr. Arbitrator. I think it's the appellant's right to do this rebuttal, if I'm not mistaken.
Yes, please. Keep it brief, please. Thank you.
Okay, thank you. Firstly, the opposing counsel actually failed to point out the difference between criminal proceedings and ethical proceedings. So the parties in here have to rely on the FIFA Code of Ethics, not the criminal case. And additionally, opposing counsel asked the counsel for the appellant a question. However, we cannot see any time limitation in the FIFA Code of Ethics because there is actually not in Article 27. And also, thanks to the opposing counsel, that the opposing counsel actually mentioned that the sanctions should be started with 5 years, not 15 years. It concludes our story battle. Thank you.
Thank you very much. Thank you all for your submissions. Cairo, I think Mr. Bondoky gave every response in rebuttal for your side. So unless you have any burning further points to make, I propose to move on.
So do I have time? I have 1 minute for rebuttal, right?
Very briefly, please. Very brief.
Okay, so here is so first regarding the question regarding the ethical and criminal proceedings, I referred and clarified that we shall refer to the FIFA Code of Ethics. Secondly, regarding the time, if the appellant has good manners, the reimbursement of 20,000 francs should be done right after the trip, not after 2 years and 2 months, which confirmed that he only do it after the Hardenian judge issued the convictions. And this confirms he is not of a good manners and he should be sanctioned. It should be taken into considerations. Third, the sanctions applied, we verified that he did not only committed bribery, even if he committed bribery alone and he has high football rank officials, he deserved 15 years of banning. However, he also committed 8 violations besides. So taking the facts into consideration, the banning of 15 years is very proportionate, and even it should be more. But talking in the facts, that's very proportionate in terms of the ban applied and the fine applied of 50,000 Swiss franc.
Thank you very much. Right, we'll take a short break for the panel deliberations, please. Francisco, could you place us into the breakout room, please?
Of course, Kevin. I will do it in a second.